AB 60, and thank you very much for bringing forward your bill and your hard work. Our next hearing is on AB 177, which is sponsored by Assemblywoman Seaman. Welcome to the Senate Committee on Legislative Operations. You brought a team, good girl. All right, we have Assemblywoman Shelton with, and Mr. Stewart. Fantastic. We'll let Assemblywoman Seaman start. Go ahead.
Thank you, Madam Chairwoman, for hearing AB 177 and committee members. My name is Victoria Seaman. I represent Assembly District 34, and I'm here to present a bill that is both personal and necessary. And with me, as you stated, is Assemblywoman Shelton, who represents District 10. Both of us have personal experience with some of the wrongs this bill seeks to right, and we thought it appropriate to be here together. AB 177 has four chief goals. First, it ensures that no candidate for this legislature is above the law. Second, it removes the partisanship that has distorted the law. Third, it makes sure that only eligible candidates who actually receive votes in their district become members of the legislature. Fourth, it promotes the spirit behind representative democracy in that an elected representative should be a member of the community he or she is elected to represent. I will now speak to each goal. Perhaps most important of all, AB 177 makes it clear that no legislative candidate is above the law. Every legislative session, we members of the legislature craft, revise, and create law that we expect our fellow Nevadans to follow. We should not allow ourselves to ignore the laws we pass when it is politically convenient. Both the Nevada Constitution and state statutes require elected officials to be qualified electors in the district he or she represents. The problem with current law, however, is not necessarily its lack of appropriate restrictions, but the apparent lack of any remedy when the law is violated. In the last two election cycles, 3 different candidates were declared ineligible for office by a district court judge. But the fact that these candidates were ineligible by law this legislator created does not seem to have concerned the legislature. One of the candidates was seated anyway, and the other 2 candidates may have been seated had they won on Election Day. One of these candidates was my opponent in 2014. She was not eligible to represent District 34. Her declaration of candidacy contained false statements. And despite the time and expense of having a judge rule that she was ineligible for office, had I not won on Election Day, she could have ended up representing District 34 anyway. That would have been an injustice. The same thing occurred in Assemblywoman Shelton's race. Allowing ineligible candidates to serve is wrong, and it sends the wrong message. When we ignore the laws that apply to us, we tell our fellow Nevadans that we are above the very laws we help write. This bill will prevent that injustice and ensure that our laws apply to all Nevadans without exception. The second goal is partisan problems. One of the problems with current law is that it puts the fox in charge of the hen house. How the law is applied depends on the partisan makeup of the body. If Democrats are in charge, they will vote to seat Democrats, even if the Democrat at issue was declared ineligible. And I have no reason to think that Republicans would do the same when faced with similar options. Should AB 177 become law, a candidate's eligibility to run for office will no longer be treated as a political football. The law will not change depending on the political affiliates of the candidate or the party in the majority. What it will do is close the loophole of partisanship. The third goal is only eligible candidates win. This bill will make sure that the only eligible candidate who received the most votes in the election will win. Members of the district will be assured that their representative is not only eligible for office, but was also the eligible candidate that received the most votes. Rather than turn the process over to the county commission to appoint someone who was never vetted during the campaign, the law will award actual eligible candidates who received votes. And the fourth goal is for better representation. AB 177 will also promote better representation. The Nevada Constitution requires representatives to come from their district they represent. Such a requirement recognizes the value in having a representative who share the concerns of his or her constituents. A representative that comes from the community he or she lives in has a better understanding of the needs of the district. Nobody knows the people and the neighborhoods of a district better than someone who lives there. This is one of the reasons I also increased the residency requirements to run for office. Asking candidates to spend 2 years in Nevada and 6 months in their districts before they run is not only sensible, but it is well within the range of such requirements throughout the 50 states. In fact, even with these added demands, Nevada will still have some of the lowest residency requirements in the nation. With that, I would like to turn the time over to Assemblywoman Shelton, and then, if you don't mind, Mr. Stewart will present the sections of the bill.
Thank you, Madam Chair and members of the committee. It's great to be here this afternoon. I just want to give you a little different outlook on the bill as far as how it affected me personally. I know right now throughout the session, we're asked to make decisions for our constituents, and sometimes we know how they feel and sometimes we don't know how they feel. But for AB 177, I can let you know how they felt on both sides of the party because we've talked to both sides of the party. We had different situations where in Assemblywoman Seaman's case, they were a little bit more on the ball, and her court case came down during the time, so she was able to reach out to voters during early voting. I, however, was not that fortunate because the judge didn't make the decision until the last day of early voting. So they were able to get the signs up and post those for some of the voters that were coming, but what we did notice is that people really weren't paying attention to those signs. So then on election day, what we did is went to the precincts in our district that had the where the voting was taking place, and had some of our family members educate the voters on what had taken place. Most of them weren't aware, and when we showed them the court order, they did not want to vote for an ineligible candidate. It didn't matter whether they were Republican or Democrat, that just the sense that somebody was voting to represent them that was ineligible did not sit well with the voters, at least the ones that we spoke to in District 10. And I'm sure Ms. Seaman can attest to that her voters also spoke loudly on election day when they placed their vote. So I would just ask you to support AB 177. I think it's what our constituents want and what the people of the state of Nevada want.
Thank you, Ms. Shelton. Mr. Stewart?
Yes, thank you, Madam Chair, members of the committee. Daniel Stewart. My official role at this point is I'm a policy advisor with the Assembly leadership team, and I have helped advise the two great members of the Assembly here as they've helped draft this bill and try to work out some issues. I'm going to try to do something a little different than I did when we walked through it in the Assembly. When I walked through it in the Assembly, I went section by section, and the topics jump around quite a bit. It's probably best to just think of it more in a hypothetical election situation and walk through it kind of in the topic by topic. To begin, this bill deals with qualified candidates, or at least enforcing the restrictions on what is a qualified candidate. Currently in the Constitution and in the statutes, you have to be a qualified elector of the district that you represent as a member of the legislature. The time durations in there are, I believe, 30 days as a member of your district, and was it 1 year as a resident of the state of Nevada. We've added to those qualifications only in the sense of we've added 180 days that you have to live in your district and 2 years for the state of Nevada. the governor has to be a resident of 2 years. That's in the Constitution, so we felt not going beyond what's already in the state constitution there. There's also some statutory terms for eligibility. So you have to be mentally competent. To speak in the negative, if you're declared insane or mentally incompetent by a court, you are not eligible to serve. You could die and hence no longer be eligible to serve. There's also two that we've added here, which is that you haven't met any of the qualifications set by statute of the Constitution, or a court of competent jurisdiction finds that you're disqualified. If any of those situations occur, you're deemed an ineligible candidate. Okay? The rest of the bill speaks to what that means. Okay? If this is before any changes can be made to the ballot, which is the end of July, then your name, if you're an ineligible candidate, your name will be removed from the ballot. And the election will continue forward. If your name was removed from the ballot because you were declared, you died, or you were declared adjudicated insane or mentally incompetent, your party then has an opportunity, if you're a major or minor party, your party then has a chance to select a replacement to fill in that place for the general election. We did not allow that vacancy of provision to also apply to individuals that have been declared ineligible by virtue of residency issues. We felt that at the part of the issues that were coming up with these residencies were parties, to the extent that they could, or maybe during primaries, weren't vetting their candidates, and hence we were getting to the general election period when these things were being found. This will give the incentives to push those investigations up further, so that we don't have any instances where you have a ballot that may have an ineligible candidate on it. After the ballot is the change period can occur, whether you no longer make any changes to the ballot. There's two pretty simple remedies, and this is probably the real meat of this law. If after the ballot's printed and your name goes out, you're declared ineligible, the registrars still have to go through the process that they've done before, putting up signs in the election office, putting stickers where they can be seen, so that the voters know. We really want voters to know that if that casting a vote for an eligible candidate, that they will essentially lose their opportunity to select this candidate. But there will be signs, there'll be stickers on absentee ballots, there'll be stickers that go out informing the voters that the person's been declared ineligible. The real meat, though, is if that person ends up winning, the ineligible candidate ends up having the most votes, those votes aren't counted. Just like for probably the best example would be the 2014 primary for the Democrat gubernatorial race, in that none of these candidates actually finished first, but those votes were disregarded and they went to the person that came in second. This is essentially what will be happening here, is that if you're an ineligible candidate and you finish first on the ballot, you will be disregarded and will go to the person that finishes second at that point. So any vote, and this will be on all the notices to the voters, any vote for an ineligible candidate will be declared null and void, just as if you were voting for none of these candidates at this time. The bill also deals with the various challenge periods, the mechanism for actually, yes?
Can I stop you for a second? So one concern is, and maybe it's a good time to stop you now, and mine would be that let's assume that we had an awesome Republican that was found to be ineligible, and they won the race. I know, seriously, I just had to make that up just so that it would kind of like stimulate everybody. But let's just, because I don't want to have a party line conversation, but let's just assume that, and that they were, let's just say they ran away with the race. They were 60-some% ahead. And then by disqualifying those votes and giving it to the second person, it's basically saying the non-majority candidate won. And I get the fact that the first candidate was ineligible, but by way that they lied or did something. But I'm just wondering, if you go back to the core of, we now have somebody who won an election who wasn't a majority. Has the people's voices really been heard, and is that okay? Go ahead.
It's Daniel Stewart for the record. Let me see if I can best answer the question. I think the from the testimony from meeting with their constituents, I think the constituents would be very okay with this. I mean, and this, again, this is something that's happened before. It happened, again, with none of these candidates. The vote of the people in the primary in 2014 was that there be no candidates in the primary, the Democratic gubernatorial primary, and that was declared null and void. So it is a heavy punishment, but we feel like it's the best way to discourage those from running that are ineligible, and then just hoping that their win on election day can save them, I think.
Yeah, I want to go, yeah. Really quickly, Madam Chairwoman, there's obviously a few things I don't like about this bill. And Madam Chairwoman, you said a moment ago that the Assembly worked out all their bills. They obviously didn't on this one because it's 2517. But my question is this. So using your analogy that you just used, and I'm where the chairwoman is, so you have an individual, and I don't care what party they are, but just for the sake of challenging my chairwoman, it was an awesome Democrat, and they got 70% of the vote. And so because of this, that person's gone, and the person that you're seeking to put in would be the person who got 30% of the vote. I get all the whole residency requirement, everything. I get all of that. But you're going to put someone in office who got 30% of the vote, who the district rejected. Okay? That is what happened. The district rejected this person. They chose the other person, not based on their residency requirements, but they chose the other person based on their, probably, I hope, on their policy decisions, where they stand on issues, et cetera, and you're going to make the district take the person that they just said they don't want. That makes absolutely no sense to me.
Madam Chair, through you to Senator Atkinson, the problem that here's what we faced. We got a district court judge to declare her ineligible the day before early voting. Okay, so...
And I get we can make this personal, and I'm trying not to do that. I know you guys have skin in the game.
Would you like me to finish the answer? So this is what happened. The constituents, when they found out that the opponent was declared ineligible, those who had already voted that we had either written, called, or visited, stated that they would not have voted for that candidate had they known, because honesty and integrity in the election trumped any policy. That was the feedback that we received. When she was declared ineligible because of the Andrew Martin situation 2 years prior, the party put in over $50,000, and we were having 3 postcards a day stating that she wasn't declared ineligible, she could still be seated. I have the flyers. So we worked twice as hard to go out and let people know that she had been declared ineligible, because we knew by talking to constituents that this was more important than any policy thing, was to have a representative who wasn't breaking the law before they write the law. I hope that answered your question.
Well, it doesn't, because it still exists. The issue is still the same. The issue is still, thank goodness it worked in your case. Thank goodness it worked in your case. I wasn't a fan of what happened with Andrew Martin, and he was seated. So I'll go on record as saying that, and I've said this in this committee. But the fact is, again, your voters changed their mind based on this one issue. This one issue they changed their mind on. So they decided to put someone in office over this one issue. Fine, I don't have an issue with that. But again, in this scenario where this election's over, someone gets 70%, someone gets 30%, someone gets 60%, someone gets 50%, someone gets 55, 45, whatever number. That was pretty good. I've never been able to do numbers like that. But that is the case. So again, I think that this needs to be changed somewhat to reflect that, because it doesn't. I don't agree with putting someone in office And I've said that before, even in other instances where someone has lost a race just in the same election, and either the county commission or the city council, whatever, wants to appoint that person who just lost to a seat. That makes no sense to me. The voters said no.
I appreciate that. I do want to say, though, I don't know if I would have won by more than 26 points had they not put all that money. So I'm not saying in this election, I don't know if they only voted for me and changed their mind or they were already voting for me, but I do know that people were very disenfranchised by what had happened. But I really do appreciate what you're saying.
So, Madam Assemblywoman, are you suggesting that had that not happened, you wouldn't have won?
No, I was saying I don't know if I would have won by more points if people actually knew.
I mean, we all run numbers all the time. Did your numbers indicate you were winning?
Yeah.
Okay.
Okay.
So I think this issue, and maybe we can just think about it just a little bit. Go ahead, sir.
Madam Chair, through you to Senator Atkinson, and to answer your question too, I just want to just quickly, the legality issue is, again, these qualified elector requirements are constitutional requirements, and no vote of the people can overturn constitutional requirements. The second is another scenario where maybe we don't seat that person that won, and the other option was then the county commission appoints the vacancy. Then they're appointing somebody that got 0% of the vote in the election before, as opposed to somebody that at least had 30% of the vote.
No, that's an excellent point. But I think my biggest concern is, and I'll let you jump in next, is, what if it's a heavily, and I used a Republican just so
Absolutely.
that, yeah, what if it's a heavily Republican district and all of a sudden they now have a Democrat or an independent representing them? No, I get that. I'm just saying that that's something like, that's one of those, okay, let's just take a pause for a second. And I wonder, I completely agree with what the problem is that you're trying to solve. Couldn't agree more. Just want to take a step back and say, gosh, what if it was a heavily Republican district and now all of a sudden they've got a Republican or a Democrat or vice versa? Then all of a sudden I feel like, well, maybe the will of the people in that district who isn't being heard or isn't being represented. And so maybe offline you guys can help me with that, but I think that that's probably both of our concerns. Yes.
Madam Chair, I'm
Yes,
sorry.
Sorry. Senator Brower?
Yeah, thank you very much. And if I'm understanding the debate about this part of the bill correctly, first of all, if you're ineligible, you're ineligible. You never should have been on the ballot. But for your misrepresentation, as confirmed by a judge of competent jurisdiction, you never should have been on the ballot. But the alternative, I guess, to not disqualifying the victor who had violated the law, who was adjudicated to have violated the law, is to allow him or her to be seated despite a court having, after an evidentiary hearing, having determined them to not be eligible to have even run, let alone be seated. And that seems untenable, and I think is the point of this bill in part, right, to eliminate. And I would go back to the Andrew Martin example. I would concur with my colleague. That was outrageous. It was outrageous, frankly, to sit on one end of the building and watch the other end of the building, and apparently the outrage was bipartisan, and see that someone, again, who had been adjudicated after an evidentiary hearing by a judge in Clark County to not be eligible, be seated, and no one in the other chamber say a word about it, or at least do anything about it. It was shocking to me, frankly, and every session that I've been here, there's always a rumor about legislator so-and-so not really living in their district, but we're talking about a case having gone to an evidentiary hearing and a judge finding after that hearing that the person was ineligible, and still that person being seated because there was nothing in the law at that time, which is why we're here today. So I hear my colleagues' concerns. I just don't know that the alternative is something that we can stand by and accept any longer. It just seems totally illogical.
Madam Chairwoman, I agree with my colleague to the extent that how we're trying to replace that person. I don't think you'll get any argument from anyone up here that says the person shouldn't be seated. I strongly believe that. But you're going to, and Madam Chairwoman, I'll use the example you just used. My district is 67% Democrat, 14% Republican. Hopefully, when I bought my new house last year, that it's in my borders. Don't go checking. I've already checked. But just to say that that was the case. And so you're going to replace a Democratic a Democratic person in a district that's 64% Democrat, 14% Republican. I don't care how you do the math. I'm not saying I'm in a safe district. I'm just saying there's no way that should happen. That's all I'm saying. You want to find another way? I think we already have a mechanism in place, but the county commission seats them. If you want to say they don't get seated and the county commission appoints their success, I'm okay with that. But to arbitrarily let the second person be seated, I don't think that that's fair either. I just don't think that that's a good alternative. Just because you happen to be on the ballot where the person violated their residency requirement, you get to be the victor. The voters said they don't want you.
Yes.
Yeah, if I could just, again, Senator Atkinson makes a very interesting point. The problem, as I see it, is that where do we draw the line? So we see in this session, perhaps like never before, we see Republicans elected to the legislature representing majority Democratic districts. So perhaps none with a registration disadvantage like a Republican would have in Senator Atkinson's district. But where do we draw the line? Do we say that you can't be seated if you just won a 10-point district the other way or a 20-point district the other way? Because I think it's unfair to assume that in any given district, the majority of registered voters would never vote for a person of the other party. We've just seen too many, perhaps anomalous examples of that this session.
Yeah. So maybe we can put a pin in. Go ahead. So let me just say this. Go ahead and finish, and then I'll let you finish. Go ahead. Go ahead, Assemblywoman. Go ahead.
I just wanted to say that this is a great example of Assemblywoman Shelton and I. We're in Democrat districts, but Democrats chose to vote for us over our Democrat opponent, some of them because of the situation, I'm sure, of being an ineligible candidate. And I don't know how to explain. We were out in the district. I walked it 3 times. I was able to resonate with the constituents. And I think that this is really what this bill is about. It's not about parties. It's about the constituents and what they deserve to have candidates who are going to represent them, who are honest and have integrity, the same as when they're campaigning as when they're up here. And I think that right there shows you that they didn't really care about party. They cared about who was going to represent them best.
Okay. Yes, Senator.
Thank you, Madam Chairwoman. I think you're way off base, and that's not what I'm suggesting. So that is not what I'm suggesting, because you guys could be Democrats sitting here having the same argument, and I would still say the same thing. So this isn't about party for me. This is about the will of the people. Amen, it worked in your case. We can have a debate all day on what your voters assumed or why they voted for you. A red wave in this state this year. We get it. We lost. No one has an issue with that. I certainly don't. But how we replace that person is a point of contention to me. Thanks.
So I just want to make one question. I'm going to let you finish your portion of the testimony, but maybe looking in some other states to see how they've handled this, so that there's some ideas that maybe sit better with the committee, because I think we all agree on what you're trying to accomplish. I wonder if there's a way everybody can feel a little bit better about it. But go ahead.
Yes, Madam Chair, Daniel Stewart for the record. I'd be happy to look into other states as well and see what they say. I think the last thing we could say is, just from talking to the Assemblywoman on this, one of the reasons for the hammer, I guess, for lack of a better word here, is to really, since it's going to be the parties that seem to care, whether they may not care about the candidate, but they care about the party label at the end of the candidate's name when they come up here for majority status. Since the parties are going to have a vested interest in making sure that none of their candidates are declared ineligible, the hope is that something like this will help a vetting process earlier in the process. I think that's at least going through the the intent of the bill was to hopefully mean the primary or so forth. I had very little more to include. I think we've talked about the meat, but I do want to make sure and discuss a proposed amendment by Clark County. There are a couple ways that these challenges can occur. One is the official challenge period, where you inform the filing officer and they investigate it. Currently in the bill, we've extended that challenge period all the way up until the beginning of early voting, the first Friday before early voting. In discussions with the various registrars, since we're talking about a very specific thing in a county challenge period or a filing challenge period, we think it's probably best to move it back to the date that it was, which was the end of July. Having said that, there is nothing in there prevents somebody from filing their own lawsuit, which is what has happened. And in all cases, one of the things we've added in this bill, at the request of clerks and other people, is the prevailing party in these cases. If it's the person that's challenging, if it's the district court, if it's attorney general or district attorney, attorney general, or private individual, the prevailing party now will have an opportunity to recoup their fees as well.
Okay. So I just can I make one comment real quick, and I just want to say something that might be a little bit different. So Assemblyman Seaman, I knew, walked her district 3 times. I think you would have won. There's some people that all they did was fill out the piece of paper and they won, and I'm just wondering, that was kind of flukish. But in a real election, where people got out and actually did what you did or worked hard and talked to the voters and stuff like that, that's what I'm concerned about, is that making sure that they, even if a Republican had won but was disqualified, that for somehow that those constituents are represented as they would have voted or would have wanted. And so go ahead, please.
Thank you, and I agree with you, but I did have to spend weeks in court,
Yes.
a lot of money, so luckily and through my hard work I did win. But this is something, if the ineligible candidate is declared ineligible, we wouldn't have to counter again after going through the court case and spending money, my own campaign money, and then having to go out and send out flyers saying that we had. I can just tell you that when a candidate is not when they're declared ineligible, but they can still win, it's a disservice to the other candidates. It's a disservice to the constituents.
I agree. Senator Settlemeyer?
Thank you, Madam Chair. And I understand the previous discussion we had. I don't think there's anybody on this committee, though, that we'd all agree. The person who did a fraudulent act and was proven by court should not in any way, shape, or form be seated. It's just a question of how do you get to the next alternative. With that, though, I just wanted to clarify your change on sections 9 and 21, because that was one of the problems I had, so you're not going to change the deadline at all, because one of the things I saw within the bill, if it changed the deadline, is the amount of shenanigans that your opponents would utilize to continually file actions against you all the way up to the Monday preceding the general election. I find that very problematic. So you're indicating that has been changed back to existing law?
Daniel Stewart, for the record. Yes and no. I hate to give you the lawyer answer there. The yes answer is with respect to official challenges. That's where you lodge a challenge with the registrar. That deadline is placed. However, that deadline the challenge period isn't the only way you can try to bring an action. My understanding is the lawsuits that were brought were for injunction, declaratory relief, injunctions, and so forth, and those you can file up to any time.
Yeah, nothing will ever stop lawsuits. I get that. But as far as the other process, we're moving that date back to where it was. Thank you.
Thank you.
Yes, Senator?
Thank you. And real quick, while you're on that note, can you help me? And I know you spoke about, and I don't remember what section it's in because, Madam Chairwoman, this bill's larger than your bill. But the 2 years, 6 months, right now it's 30 days. Right now it's 30 days, correct? And a year?
6 and 23. Section 6 and section 23.
Okay, well, same thing. But so explain the change there.
Daniel Stewart, for the record, through you, Madam Chair, to Senator Atkinson. My understanding of the change there is twofold. One was to Nevada still has a very low, even with these requirements in, still has a very low time period that somebody has to stay in their districts. There's some we found in New York and Texas where you have to live in your districts for up to 5 years before you run. Initially, Assemblywoman Seaman had 1 year and 5 years, I believe, 1 year in your district, 5 years in Nevada. Through discussions with members of the community, we felt like we needed to push those back. Now, to get you to answer your question, why? Well, on the one hand, we could ask why have any residency time frames? I mean, why 30 days?
I'm asking you why you're not. I don't want a challenging question. I'm just asking you what was the reason for that.
Okay, the reasons I believe were twofold. One was that if the deadline is stretched back, at least within the district, to 180 days, that itself would help discourage candidates from jumping around from district to district. In that, now that it's only 30 days, maybe somebody decides at the last minute that they want to run. They look at where they live. They find out that they have a great representative already, so then they start looking at other districts. This was to eventually push back against that. The second thing is to basically get to the core of representative democracy, the idea that the members that serve their districts actually come from their districts. They know the concerns. They have a personal relationship with their constituents, so that when we're up here in this fast 120 days, that they really can help bring the benefits to their districts, but also live with the burdens that they might impose on their districts. And my understanding is it was those two reasons for expanding the requirements. Okay,
and then I get that on the residency within the district, but then we're changing how long someone lives in the state. The only thing I'm going to say to that is I'm not sure that the argument that you're making, 30 days, 6 months, suggests that, because they don't. You can have someone who lives, and I'll use myself as an example, who lived a few blocks outside of the Senate district that I represent now, but because of redistricting had to move as a result of that, and it happened pretty quickly. So to make the argument you don't know, I mean, obviously I knew where I was going, and obviously had name recognition there, and obviously knew the folks right across the street. So what I'm suggesting to you is that it can happen where you have had to do that. Had happened to Luis Valera, who was my very first opponent. Kind of the same thing happened to Bob Price, my very first general election opponent, got drawn out of his own assembly district by a couple blocks. These folks still knew him. I mean, they absolutely knew who he was, but those things happen. I'm just suggesting when we start making these things so strenuous, I don't ever want to be compared to Texas, but those things happen. And so if we're starting to get so strict, we have a transient state. We have people here who have been in office, been in the state less than 2 years, who I think are fine representatives, not only in this branch, but have served in other branches and are. So I just think that when we're starting to get so inflexible of good people being on the ballot, then we're doing our state a huge injustice.
Yes, thank
Madam
you.
Chair,
Yes.
Through you to Senator Atkinson. I lived in my district a couple years. I've lived in that district on up, but 2 years in that district, and my district is so diverse and so different that it took me months to walk the different areas, even though I shopped there, I lived there, I did everything there, to really get to know some of the issues in different areas and pockets of the district. So I think having an investment of 180 days to come up here and be a good representative and steward for the constituents is something that a lot of the constituents asked for. When I explained to them that you only had to be in a district for 30 days, my constituents were shocked. They couldn't believe that somebody would live there for 30 days and actually be able to represent them. So a lot of the issues and concerns for AB 177 are actually coming from the constituents and the people of the state of Nevada. This is something that they really felt more comfortable with.
And Madam Chairwoman, just real quick, you keep talking about your district. Your district doesn't represent the rest of our districts. 14 years, I've never heard this topic. Even while this was going on, I didn't hear it. Of course, it was an issue during the campaign for your district. You're not like any other candidate. I mean, people told me I couldn't walk a Senate district. I did it twice. And so people do that. And I think that is the way that the legislative races should work. You should get out there. You should campaign. You should work. You should walk. But you're speaking for your district, and I respect that. But that's not necessarily true for everywhere. And you went through the incident, and Ms. Sheldon, you went through the incident. And again, I commend you guys for it. But your districts don't speak for the rest of the 42.
Okay. Anything else further from this panel? Any other questions? Yep, Senator Segerbloom.
I just wanted to comment on, you mentioned Assemblywoman Seaman. I want to comment on Assemblywoman Shelton, who's my Assemblywoman, who's worked hard, too, to get there. So I just want to make sure she gets credit for legitimately beating a Democrat. Although he wasn't a very good Democrat.
Ms. Sheldon asking for a check.
Yes.
Yeah.
Next election. Okay. Any other questions of this panel? Okay. Seeing none, I'm going to go ahead and ask anybody. I think we have some Las Vegans down there wishing to comment. Are you in support of this bill?
Both of us are.
Okay, go ahead. And I'm going to before you start, let me ask if there's anybody else in favor of AB 177 to please come forward in Carson City. But I'm going to go ahead and let the folks in Las Vegas start. Go ahead.
Thank you, Madam Chair. This is Jacob Reynolds from the law firm of Hutchison and Steffen. I represented Miss Victoria Seaman in her lawsuit against Megan Smith in Las Vegas. I wanted to talk about being in favor of this bill and some of the things I observed as an attorney in the case. This type of problem goes to the core of public trust and a belief that the system is not rigged. If a person can lie on their declaration of candidacy, be declared ineligible and disqualified by a court, and still be seated, it destroys public confidence in the integrity of elections and public confidence in the integrity of the system. Just a few points. In this specific instance, the opposition, the person we were opposing, the one we had sued, she could not even identify the home where she supposedly lived on a map. She could not give me an address of where she supposedly lived. She was someone who had run in 2 different districts. It was a carpetbagger type of politician trying to find a good, solid Democrat district. I believe Ms. Seaman was 14 points down registration, but still managed to win this election. And this other person had tried to go to different districts previously, 2 times previously, to win elections, and thought that this 3rd time was the charm. It wasn't. We had to go to a full trial. It was not just an evidentiary hearing, it was a full trial. And we were able to talk about these kind of things, but what does the bill address? The party, the people on the ballots, if they want to run as an independent, they can. But if you want to run as a party and have a party tag on your name so that those 70% registered in your party can vote for you, then that party should be responsible for filtering the candidates and making sure you are eligible. Attorney fees provision, real quick. There is an attorney's fees provision for people who successfully defend a challenge already. That attorney fees provision exists, but for people who successfully challenge a candidate, there is no attorney fees provision. So if Megan Smith had won the challenge, she could have received her attorney fees and costs, but Ms. Seaman had no avenue to get her attorney fees and costs, so that should be included in the bill, so it's at least an equal playing field for the people involved in the challenge. I wanted to just say that these lawsuits are ordained, condoned by the Nevada Supreme Court. They are allowed for good reason. The Nevada Supreme Court has already said they are always allowed up till the time of filing, up till the time of the election for declaratory relief. We're able to seek that in court. And also the Nevada Supreme Court has specifically said not just for Assembly District 34, but for all districts, the public policy is articulated to be that the person must have a connection with the district. That is the concern established by the Nevada Supreme Court for all districts in Nevada. Thank you.
Thank you.
Good afternoon, Chairman Farley. I'm retired Air Force Colonel Robert Frank, and I'm speaking on behalf of 177. I went through the entire process. By the way, I'm representing the Citizens Task Force for Voter Rights, which is a nonpartisan, unpaid group of volunteers who are concerned about various election integrity issues, including 177. We helped provide input to the 177 language, and one of the things that I haven't heard this afternoon that I'd like to emphasize, if I may, and that is that as a layperson, as a person who's a computer scientist involved in computer security and so forth, but trying to deal with common sense, to me, when I first heard of the situation, I could not believe my ears when it came out that someone could deliberately lie on their application and still wind their way through a process that seemed to be completely untrustworthy and wind up still being elected. It didn't make any sense to me at all. And I believe that this 177, one of the major intents of the participation that I've been involved in with Assemblyman Seaman was that the Assemblywoman Seaman was the fact that the process should eliminate this kind of a person who is trying to game the system as early as possible, particularly before the primary, and for darn sure long before the ballots are printed. We should never, as a citizen in this state, have to worry about if there are corruption or ineligible people or declared ineligible people on the ballot that might not be qualified to be seated. That makes no sense at all. So as a layperson and as somebody who's trying to deal with just plain old common sense, the Secretary of State should, in fact, eliminate the possibility as high as possible so that a person can't show up on the ballot and still be ineligible. But having said that, some of the original draft language in there, and I believe most of it still survives, that says that even if you did by accident wind up on the ballot, there are provisions that would make sure that every person who votes has a chance to be told personally, and not have to worry about whether they read a sign or not, told personally that this person cannot be elected. And if you choose to vote for them, you're wasting your vote because your vote will be ineligible. You should pick from any other candidate besides this one because it was a mistake to be on the ballot. That's what I thought this whole bill was about. And if it's not, then we missed the point, because the argument I heard about, well, it'd be a shame for people that are uninformed and don't know that the person is ineligible, vote them in anyway. That doesn't make sense to make that possible. They should be told before they vote, at the time they vote, that the person is ineligible and that their vote won't count. That way you don't have to disallow it. It never was counted in the first place. It should never be certified. That's my simplistic way of dealing with it, and I hope the Senate committee will in fact look at it from a layman's point of view and not necessarily from a legal or political point of view, but just common sense. Thank you very much.
Thank you. And just in the reference of time and whatnot, so I want to probably make it really clear and speak on behalf of my committee in the sense that everybody thinks it's wrong, and that we all probably agree that the person who is found guilty should not be seated. Some of us are thinking about what maybe is some alternatives so that we get comfortable with it. So if you have testimony that's not trying to convince us of what we already probably believe, that's phenomenal. And we'd like to hear that and not try to convince us of what we already know. And so with that said, just because of time, if you've got additional stuff, let's go ahead and start up here in Carson City. Sir, go ahead.
Thank you, Madam Chairman. Senators, for the record, my name is John Wagner. I'm chairman of the state chairman of the Independent American Party, and we don't have this problem because we vent our candidates at conventions. Now, to me, you file in March, or as last time, you've got a long time for court action to take place. The party themselves, the state party, the state central committee or county central committees should have some responsibility in saying, hey, you're the wrong guy, get out of here. And then at which time maybe they can put in a substitute candidate to run the rest of the time. But we had differences with the bill in the other house. They resolved those differences, and we support the bill. Thank you.
Yes, go ahead. Let me let Senator Atkinson.
Just real quick, don't go anywhere, John. Where's my girl Janine?
Yeah.
I got Lynn in here instead. I got it.
Yeah, she's in another meeting, so there's too many meetings going on at the same time.
Tell her I need her when you get a chance.
I'll tell her that.
But real quick, so I understand your scenario, and I heard the gentleman earlier say about the parties and vetting their candidates, et cetera, et cetera. Let's be real. This is democracy. If someone wants to file for office, they're going to. It has nothing to do with the Democratic Party. It has nothing to do with the Republican Party. It has nothing to do with the Independent Party. You can vet them all you want, but when it comes time to signing up and putting your $100 on black, and I say black because I'm black, but anyone could go do that. You can't stop a rogue candidate from going to file. I mean, and if they get on the ballot and they win, whatever, that's their choice. We can't stop anybody from filing. So you can do this vetting process all you want, and you can put your candidate on, but then stop another independent person from filing. Just to let you know, Janine's in the room.
Yeah.
Thank you. That was just my comment to that, John.
Okay. Senator Atkinson was missing you. Ms. Hansen. Sir, go ahead.
Tony Shelton, Policy Director for Assemblywoman Shelley Shelton. I'm also her husband, so I have a little bit of insight on what happened during her campaign. But the purpose of this bill is not to change the results of an election. The hope is that longer residency requirements will create a closer bond with the community and an honest representation of the voters. The voters understand that. When during her campaign, family members, like she said, were at the polling booths, and I was the guy to go around and get water for everybody and food and things like that. But I did have to stand in for 2 hours, and I talked to everyone that I could get a chance to. I watched 21 voters change their little booklets of who they were going to vote for. All 21 of those were Democrats, and every one of them said that they would rather vote, and some of them said it in kind of a funny way, they would rather vote for an honest Republican than for a Democrat that didn't tell the truth. And I believe that's the way most voters feel. They want to vote for the candidate that's honest. And like I said, nobody wants to change any results of an election. Hopefully the end result of this would be that we get honest politicians that learn who the people are in their district, live among their district, become a part of their district, and represent their people that way. Thank you.
Senator
Madam
Atkinson.
Chairwoman, can you, Mr. Shelton, can you do me a favor? Can you get us the 21 Democrats that voted for her? Because I need to talk to them.
Sir, go ahead.
Good afternoon, Madam Chairwoman and members of the committee. For the record, John Fudenberg, representing Clark County. I just wanted to state for the record that we do support this bill with the proposed amendments that Mr. Stewart mentioned earlier. Thank you.
Thank you.
Can I just,
Yep, Senator.
Mr. Fudenberg, aren't you the coroner now? Do they still have you testifying on election bills? Holy cow.
Can you imagine that?
Yeah.
Elections, dead people, very similar concepts.
Yeah. Wow. Multifaceted. Thank you very much.
Thank you.
I think that's not good to have the coroner be active in politics because there's a lot of bodies out there that could be voting.
That's right. Oh, gosh. Okay. Anyone else wishing to speak in favor of AB 177? Please come forward. Come on up, Janine. Senator Atkinson is very happy that you're here.
I'm very happy to be here as always. Thank you, Madam Chairman, members of the committee. We were very appreciative of Assemblywoman Seaman in responding to our concerns about this bill in the Assembly and the changes that were made, the adoption of the amendments. And so we support it with the changes that were made in the Assembly. So thank you very much.
Thank you very much. Anyone else wishing to testify in favor? Anyone wishing to testify in opposition to AB 177? Anyone wishing to testify in the neutral? Okay, seeing none, I'll invite the bill sponsors back up for final closing.
Thank you. I appreciate you all hearing this bill today. And I have to say that the meat of the bill is not to allow ineligible candidates to be seated or their votes counted. What would be a tragedy, or a travesty, I should say, is to punish the person who spent all the time taking them to court by allowing someone else to replace them if they do get more votes when they had 0 votes and weren't out in the community. So I must say that we needed a remedy for someone who was declared ineligible. We worked really hard on this, and this is the remedy we thought would be nonpartisan. And again, I think it will deter a lot of people from filing false affidavits and claiming to live in a residence where they don't live. Do you have anything to add?
Thank you very much. Lots of work, and I knew that you guys did a great job in the assembly of working with everybody, so thank you very much. Seeing no other testimony, I'm going to go ahead and close the hearing on AB 177.